Dear ladies and gentlemen, it is both great honor and joy to be able to contribute to this fine series of the transatlantic legal online lectures. Since I have been a part of the Leibniz University of Hannover for almost 2 decades now, which is also a great honor and joy to me, it appears as natural to have picked for my topic for this online lecture the matter of the best of all possible unions, question mark, lessons learned for the European Union through Leibniz and through Voltaire's Candide. And you know, of course, that Gottfried Wilhelm Leibniz in 1710, in his work Essai de théodicée sur la bonté de Dieu, la liberté de l'homme et l'origine du mal, tried to point out and to maybe justify to some extent certain pathologies of the world by emphasizing that this present world is the best, the optimal, if you will, among all possible worlds, and it appears to be the most balanced one due to the fact that it was created by God. A view which is very sympathetic, of course, to me, and I take that as basis, since, as I have pointed out before, I'm a part of the Leibniz University of Hannover for almost 2 decades now. Some decades later, after the work of Leibniz, Voltaire issued his work, Candide ou l'optimisme, which appears to be a satirical work based on the thoughts of Leibniz, but leading the whole story of Candide to a slightly more, one could say colorful direction, if you will. In Candide, the central person is attracted to a girl named Cunegonde, and Candide appears to be of the most unaffected simplicity. Therefore, his professor, Pangloss, teaches him that they actually, all of them, live in the best of all possible worlds, based also on the divine approach of Leibniz, which I mentioned before. Voltaire, though, points out through his work that the optimism, as emphasized by Pangloss, does not correspond to reality in his point of view, and Voltaire shows it in his work by making Candide and Cunegonde actually suffer a whole lot in various episodes through the continent of Europe and through further continents, depicting, as I said, that the general approach of Leibniz was, again in Voltaire's eyes, maybe a little bit too optimistic. Through this journey, which leads them actually also to Lisbon, which is of importance vis-à-vis the Lisbon Reform Treaty, which we're going to deal with slightly later. In the end, the whole story in the eyes of Voltaire leads to a slight, one could say, happy end. Of course, Cunegonde has suffered a whole lot, but she and Candide are married in the end, and they are purchasing a small farm in which they are capable of living a quite peaceful life, which at the end of the day could emphasize, and also Voltaire then of course obviously wants to point that out, leads to the original approach of Leibniz of the best possible worlds, and it shows that also in a small picture such a world can be achieved. The European Union, now to make a bridge to our core topic here, has developed in various ways, and especially after the Lisbon Reform Treaty, it has made giant steps ahead, both regarding its institutional and its material law, but there have been also every now and then serious crises which in some cases endangered the forthcoming of the Union as a whole. I will try to depict in my modest contribution some elements regarding the institutional law of the European Union and some selected elements regarding the material law of the European Union. For instance, dealing with matters of artificial intelligence, then the constant clash with matters of climate change, and since it has been a core topic also in the case law of the European Court of Justice, I will deal heavily with matters of EU consumer protection law based on my newest work, which mirrors my contemporary lecture of European Union consumer protection law, which I have the honor and joy to deliver at the Leibniz University of Hannover. In order to start with some institutional elements and some institutional problems of the European Union, I would like to start by thinking about the necessity or not of having a bigger or a smaller Commission. You know, of course, that the Commission is at the helm of the executive branch, so to say, of the European Union, a very crucial institution. And Article 17, para 5 of the Treaty on the European Union reads that as from November 1st, 2014, the Commission shall consist of a number of members corresponding to 2/3 of the number of member states, unless the European Council, acting unanimously, decides to alter this number. Up to now, every member state is entitled to nominate one commissioner. And through this thought of para 5 of Article 17 of the Treaty on the European Union, it was tried actually to open a window to a smaller and maybe more flexible and more effective, at the end of the day, Commission. Imagine a union growing bigger and bigger, maybe also over the upcoming years, leading maybe to well over 30, 35 members. If you compare that to national governments, that is quite a huge number of people having portfolios, not leading, in the eyes of many scientists, to a very efficient institution. Of course, the or such a decision of the European Council acting anonymously was not able to be issued up to now, which is understandable, I guess, from a political point of view. Every member state would like to insist to have the opportunity to nominate its own commissioner, even having or in regard to the fact that commissioners after getting that job have to represent the union as a whole, and by no means the interests of the member state which has nominated them. It remains to be seen over the upcoming years whether the thought of Article 17, Para 5 will become reality. I highly doubt so, because, as pointed out, the member states are very much interested, of course, in having the opportunity to nominate one commissioner. And it could lead in some years to a much bigger commission with more members to it. And then it remains to be seen whether this institution will be capable of acting flexible. Moving now to another major institution of the European Union, the European Union Parliament, Article 14, Para 2 of the Treaty on the European Union states that the Parliament shall be composed of a certain number of representatives of the Union citizens, not exceeding 750 in number, plus the President. Of course, in praxis, after the Brexit, this number has been reduced to 705. In any case, Article 14, Para 2 points out that the representation of the citizens shall be digressively proportional, with a minimum threshold for the smallest countries like Malta, for instance, and Luxembourg, of 6 members. And in any case, member states shall not be allocated more than 96 seats, as it happens in the case of the Federal Republic of Germany. Again here, similar to what we saw in Article 17, Para 5 of the Treaty on the European Union in regard to the Commission, similar to that, in this Article 14, Para 2, it is stated that the European Council again shall adopt by unanimity, on the initiative of the European Parliament and with the consent of the European Parliament, a decision establishing the composition of the European Parliament in the future. Lately, in September 2023, the members of the European Parliament have approved such a decision of the European Council, which increases the number of seats in the European Parliament for the next legislative term. You know that the next election to the European Union Parliament will take place in June of 2024. To increase the number of members to the European Parliament from 705 to 720. And additional seats will be allocated, for instance, to France, Spain, and the Netherlands. 2 more seats for each of them, which is, of course, prompted by demographic changes in the European Union. And 1 further seat will be given to Austria, Denmark, Belgium, Poland, Slovakia, Finland, Slovenia, Ireland, and Latvia. Again, the future number of 720 members to the European Parliament seems to be quite big in order to guarantee an efficient work of a parliament. The member states' national parliaments do, in most cases, except the Federal Republic of Germany, that is a totally different issue, which has been element of scientific discussion and political discussion for many years, but in all the other member states, the tendency would be to reduce the members of the national parliament, making sure, if possible, that these institutions are capable of efficient work. It remains to be seen whether this increase, which is still smaller than what Article 14, Parashu of the Treaty on the European Union, of course, foresees, but it's still a respectable number in the future to have 720 members to the European Union Parliament. It remains to be seen whether this number will be helpful for the future efficient work of the Parliament. Moving now to material elements of the European Union law. It was, I think, a great success of the Union that its legislative institutions were capable of finding at last an agreement regarding the European Union's Artificial Intelligence Act, which happened lately in the end of 2023. It remains to be seen, of course, whether this pioneer work, because all over the world only the European Union has so far achieved and managed to issue such a future legal act, it remains to be seen whether it will be helpful to address the problems and needs of artificial intelligence, and in order to regulate it within the needs of society. But the whole matter of being able at last to issue such a secondary legal act is, I'd rather say, a great success for the European Union. Besides that area, there is a constant clash regarding matters of climate change, and the European Union tries, through its Green Deal, which is modified quite often over the last years, to find the best possible energy mix in order to correspond and to find the best possible answer, if possible, to the needs of climate change. It is an ongoing situation, so it would be unfair to determine right now whether the Union has been or not successful up to now in this area. It remains to be seen whether the measures of the Green Deal will be helpful at the end of the day of finding solutions to climate change, a matter which of course not only affects the European Union. Another rather important achievement, and one could say that I'm giving you a glimpse of the future right now, would be the so-called Digital Services Act and the Digital Market Act, which have been issued by the European Union. And I will consider it in the context of consumer protection, which of course within the market of the Union is a highly important element. The significance in any case of digital services in our lives is understandable in many different ways. Such services are used to communicate, they are used in order to shop, to find information, etc. All of it through constantly evolving newer digital services. And these services have made also trade across borders and the access of new markets much easier, which of course the European Union internal market at the end of the day is about. But there are also issues to address, issues which deal with the trade and exchange of illegal goods, for instance, and illegal services. And online services might also be misused by manipulative algorithmic systems and disinform especially the weaker link on the market, which is the consumer in praxis. A main issue here is still that some larger online platforms control important ecosystems within the digital economy, acting as gatekeepers on the digital markets, and leading sometimes to unfair conditions, not only for businesses using these platforms, but also for consumers. Regarding the Digital Services Act, which is now to be found in Regulation 2022/2065, due to the constantly growing significance of information society services also for consumers, and in order to enhance the most responsible behavior possible by providers of such services, the EU legislator issued the aforementioned Regulation 2022/2065, which is due to apply from February 17, 2024 onwards, and demands important parts of the Electronic Commerce Directive of 2000. The whole regulation aims, as it can be read in Article 1, Para 1 of it, it aims at setting out harmonized rules for a safe, predictable and trusted online environment that facilitates innovation and in which fundamental rights enshrined in the Charter, including the principle of consumer protection, are effectively protected. It does so, the regulation does so, especially through Articles 29 et sequentes, which include provisions regarding providers of online platforms whenever allowing consumers to conclude distance contracts with traders through said platforms. Especially also the quite excessive right to information would have to be emphasized here, as well as matters of data access and respective checks and balances, and last not least, certain conduct rules for online advertising. In any case, based on this regulation of the Digital Services Act, a non-compliance from the provider's side might very well lead to legal sanctions, also for the consumer's benefit. Taking place under the auspices of the fresh European Board for Digital Services, one cannot still determine the ultimate impact of a said secondary legal act on the market, and especially on matters of consumer protection. It has to be seen, therefore, whether it will fulfill its goals in the upcoming years. Moving then slightly to Regulation 2022/1925, regulation regarding the digital market, or the Digital Markets Act. This one here aims expressively, based on Article 1, Para 1 of the regulation, at laying down harmonized rules, ensuring for all businesses contestable and fair markets in the digital sector across the Union, where gatekeepers are present, to the benefit of business users and end users, ergo consumers. So this secondary legal act has a proper eye on the aforementioned gatekeepers again, defining quite excessively their obligations and potentially unfair practices. And non-compliance leads to legal sanctions, at the end of the day also benefiting consumers through the strengthening of their position on the market. And since this, the Digital Market Act, applies only from May 2nd, 2023 onwards, again, one has to be still patient in order to see its legal impact on the market. But finding an answer to ongoing developments of the digital sector through this digital package of the Union is to be considered per se, from my point of view, as a very important achievement of the Union. Moving now to the plain area of EU consumer protection and having a proper eye on the case law of the European Court of Justice, the European Court of Justice has been very active in emphasizing the legal provisions of the EU legislator in the area of consumer protection. Its case law affects all the thematic areas of consumer law, as mirrored through the considerable wealth of secondary legal acts issued by the European Union legislator in that area. And foremost, the case law of the European Court of Justice has managed to create the image of an averagely informed and understanding European consumer through its rich case law. And said image has influenced the EU consumer protection legislation gravely ever since. Having an eye on the case law of the European Court of Justice, it has held, for instance, that delivering costs of goods must in no case be charged to a consumer who exercises his or her right of withdrawal. It is possible, though, for consumers to be charged for the cost of good returning. Comparably, it was emphasized by the European Court of Justice judges that the consumer exercising his or her right of withdrawal does not have to compensate a seller for the use of goods in hand, unless them having been used in an improper way, in an unreasonable manner. Also, wherever potentially defective goods are replaced, consumers are by no means obliged to pay compensation for the use of them. And additionally, the seller has to remove defective goods and install replacement goods, at least alternatively bear the necessary cost of them. In a slightly different thematic area, the European Court of Justice further held that any lack of contract conformity becoming apparent within 6 months of the good delivery has presumably already existed at the time of delivery, and therefore, despite the consumer having to prove a lack of conformity apparent within 6 months, he or she is not required to prove the cause of that lack or to attribute it to the seller. In an even more contemporary manner, despite not having to do with anti-COVID vaccines, of course, it was decided that wherever a lack of scientific consensus, the proof of a defect in a vaccine and of a causal link between said defect and a potential disease can be done only by seriously consistent evidence. Moving to a slightly other area of consumer protection, insurance contracts must set out in the eyes of the European Court of Justice in the most transparent possible way, and thereby in plain and intelligible language, all functionings of the insurance agreements, enabling the consumer to determine economic consequences deriving from it. Also, in another case, taking the gender of insured individuals into account as a risk factor in insurance contracts is, in any case, constituting a discrimination. In another case, in front of the European Court of Justice, it was emphasized that consumers entering into a loan agreement through a doorstep selling situation do by no means lose their right of cancellation if not having been informed of it properly. Above all, consumers must be provided with information that fulfills the criteria of being correct, neutral, and objective. And in the case that product labeling might give the impression that the product contains a particular ingredient actually not present, a consumer could potentially be misled. In a more concrete situation in front of the European Court of Justice, a possible sodium content indicated on a mineral water bottle packaging has in any case to reflect the total amount of sodium within in order not to mislead consumers. above all, in the necessary cooperation with national courts of member states, the European Court of Justice has made clear that national courts are required to examine ex officio whether a contract term may possibly be unfair, but that does not allow the national court to revise the content of the term, but may in any case lead it to not applying such term. So that would conclude a proper overview on the case law of the European Court of Justice in the area of consumer protection, which indeed has proved to be very rich and has influenced the developments, the legislative developments in the European Union regarding consumer protection gravely. All these depicted matters of institutional European Union law and material European Union law can show, in my eyes, that despite various crises ongoing over the last years, the Union is still in the position to act efficiently, is still in the position to issue important legislative acts, and therefore one could, remembering Voltaire and above all remembering Leibniz, state that we are finding ourselves in the best possible, under the certain circumstances, union. Dear ladies and gentlemen, I'd like to thank you warmly.